Welcome to Trademark Insiders, the business and marketing podcast brought to you by Koga and Cannon. We are Mary Kogat-Lowell and Mary Cannon, national trademark attorneys, brand consultants, and business coaches. Join us to get the insider's perspective on all things business, marketing, and intellectual property. Today's story focuses on artificial intelligence and whether or not OpenAI can trademark GPT. And can they ask the USPTO to speed up the process? Today we will walk you through it all and find out how the USPTO has responded so far. MK, what does the trademark application process generally look like, and how long does it usually take?
Business owners can choose to register a trademark or apply to register a trademark either in the state or states where they're using the trademark, or they can apply with the U.S. Patent and Trademark Office in Washington. And many businesses do go ahead and apply with the USPTO because it provides nationwide trademark protection rather than just trademark protection in particular states. So to register a trademark, the business owner is going to have to file an application, and let's focus on the process in the USPTO. The application must include a description of the mark, the goods or services with which it will be used, and evidence of use in commerce. Once the application is filed, it undergoes a review process. If the mark meets all requirements, it will be published in the USPTO's official gazette, and at that point, third parties will have an opportunity to oppose the registration. If no oppositions are filed, the mark will be registered, and the owner will receive a certificate of registration. Currently, the process is taking anywhere from a year to a year and a half to complete. Every trademark application is different, so predicting a particular deadline or a particular time frame is impossible. But generally speaking, business owners should expect to spend about a year to a year and a half on the registration process.
Got you. So OpenAI's recent filing represents a strategic move aimed at protecting its unique branding and intellectual property in the field of AI and natural language processing. But the question is it that unique? OpenAI was the first to produce a so-called GPT and does remain the most prominent provider of this kind of technology. But the term GPT was used prior, and it's currently also being used quite broadly in the space to describe similar language models created by other companies and organizations. So backing up to the initials GPT and what they stand for. GPT stands for Generative Pre-trained Transformer, and that refers to a specific type of AI language model. Interestingly, though, the word transformer refers to a technology created by Google, and the phrase generative pre-trained transformer can be found in Google research papers from years ago. Ironically, some insiders think Google is OpenAI's main competitor in the space. Very interesting. So aside from the fact that OpenAI is trying to trademark the initials GPT, which could be a little dicey, they have also asked the USPTO to expedite review of their application. So basically, they wanted to skip the line. Like MK said, the wait is approximately a year to 18 months, but the company filed something basically stating they are worried about competition using the GPT mark during this long process. Unfortunately, as we know, the USPTO denied that request. MK, can you walk us through the paperwork?
OpenAI asked the USPTO to expedite review of the application, as you mentioned. Basically, they wanted to skip the line, but the lawyers did make some mistakes in their attempt to speed up the trademark application. First of all, they should have filed a petition to make special instead of a request to make special. On top of that, their filing was incomplete because it did not include the required petition fee. In addition, the evidence that they provided to support their allegations of infringement was not sufficient. They needed to include some evidence of their legal efforts to protect the mark against the alleged infringement, such as a cease and desist letter or a lawsuit. Instead, the lawyers simply attached a declaration and some web pages regarding the situation. Plus, the USPTO implied that their circumstances simply aren't special enough. After all, a large number of applicants have concerns about competitors while their registration is pending. Hence, that's the reason for applying for a mark in the first place. So the bottom line is the USPTO ended up dismissing the request for expedited review, stating that the petition lacked evidence of very special circumstances that would justify the extraordinary remedy of invoking supervisory authority under Trademark Rule 2.146 to make OpenAI's application special.
That's fascinating. And I think it's a good example of the need to be proactive when it comes to your intellectual property, because as we all know, ChatGPT has become very, very popular very quickly, and there are now many copycats out there. And, maybe it's too late for OpenAI to be able to obtain a trademark like this. In the meantime, I did notice they've published brand guidelines on their website. So although they can't outright tell people GPT is trademarked and you can't use it, they have published these guidelines where they're asking developers using the technology or a similar technology to distance their product from the word GPT. So for example, OpenAI's ChatGPT, under these brand guidelines, it would become chat powered by GPT-4. So what do you think, MK? Too little, too late? And will the application to register GPT as a trademark actually be granted?
Well, that's a really good question. It's hard to say whether this application will be granted. But let's go back again to the foundation of trademark law, which is trademarks are source identifiers. So do consumers associate this acronym GPT with this applicant, OpenAI, or is GPT a term that is widely used in the artificial intelligence community? Now, that really is the ultimate question. If there's a term in the industry, generative pre-trained transformer, which is referred to as GPT, then, and if that's used in the industry and not really associated with OpenAI, then OpenAI is going to have a hard time and ultimately will not be able to register that mark. Now, I noticed in a search of the USPTO database that several other applications are pending that include GPT. And in fact, OpenAI has another application pending for the term Chat GPT. In my opinion, they're much more likely to achieve registration of Chat GPT because that's associated, that's their particular brand. But whether they're going to be able to, to register that mark GPT, I honestly have my doubts for the reasons, I mentioned previously, because if GPT is a term that's used in the industry, then and is not exclusively associated with OpenAI, ultimately their application will be denied. And it will be interesting to see if they get to the stage where the application is published in the Gazette and there's an opportunity for opposition. I'm going to predict there's going to be a lot of opposition because already several other companies have tried or have applications pending that include GPT as part of another trademark.
Right. And even if the USPTO approves, the mark is going to enter that opposition period. And major competitors like Google, I'm sure, will jump at the chance to fight the mark's registration. And that brings us to one of the key concerns in this case. It's the potential for a trademark like GPT to be used to stifle competition and innovation, in this case, in the AI industry. So if OpenAI is successful in securing its desired trademark for GPT, that would obviously prevent other companies from using the mark and maybe even discourage them from developing similar technologies, even as other companies are developing these kinds of technologies independently and without access to GPT's proprietary information. Very interesting. And then the other big concern is the potential for this GPT trademark to be used to create a monopoly in this place of AI and natural language processing. So by securing the GPT mark, OpenAI could be potentially creating barriers for entry to other companies looking to compete in the field, which of course limits consumer choice and leads to higher prices and other ethical and legal concerns that all need to be carefully considered and addressed to ensure the industry remains open and competitive and consumers are not being unjustly limited in their choices. Because at this point, we are seeing new models, new applications emerging at a really, really rapid pace. And there's increasing investment in the industry, growing demand for AI solutions. This is a really important sector, and this is a precedent-setting trademark application. So ultimately, the future of AI is probably going to be shaped by a range of factors, including decisions like the one pending in front of the USPTO, technological advancements, regulatory developments, and very importantly, evolving social attitudes toward the use of AI. Because we know some people are very enthusiastic about it, others are more skeptical. In fact, that's probably one very positive reason to go ahead and try to obtain a mark like this. It's to increase trust and recognizability in the market. And maybe that will assist in helping companies like OpenAI shift some of the negative attitudes toward AI technology toward more of a positive one, because the consumers, the public, can recognize the source of the technology.
And definitely, governments around the world are grappling with how to regulate AI and ensure that it's used in a responsible and ethical manner. And I mean, this is a really interesting question because we're seeing changes happening at breathtaking speed. And, I'm going to be interested to see how the law responds to the entire field of AI, because traditionally the law moves kind of slowly, and in this case the industry is going on at breathtaking speed. So we'll see what happens. Definitely we need to engage in ongoing dialogue and debate about these issues to ensure that the development of AI and natural language processing technologies is ethical, responsible, and beneficial for all. So this is a really interesting, this is just a really interesting sample of a business trying to register a particular trademark in a rapidly evolving industry, and it'll be fun to see what happens.
Right. And it's a good example of the importance of having a trademark strategy, because perhaps in this case, they could have been a little bit more proactive and filed their registration earlier. Perhaps they could have done so before the USPTO was flooded with similar applications, and clearly even beyond those that have applied to the USPTO, there are, I'm sure, many, many more who haven't. This industry has been flooded with other products and companies that use the initials GPT.
That's right. And, OpenAI filed this application in December of 2022. That's, still relatively recently. And by that time, a lot of companies and the, members of the public even had heard about GPT. So again, like I was saying before, it'll be interesting to see whether the Trademark Office grants an application, which they would have to be persuaded that term GPT is associated with OpenAI. And as I said before, I have my doubts, but it'll be interesting to see how this plays out.
Thank you you for listening to the Trademark Insiders podcast. We hope you enjoyed today's episode. Remember, trademarks are an essential part of building and protecting your brand, and our goal is to provide you with the knowledge and insights you need to succeed. Visit us at trademarkinsiders.com for more information, and don't forget to subscribe to our podcast to stay up to date on the latest trends, news, and strategies in the world of trademarks. Protect your brand, protect your business, and join us next time for more insider tips and tricks on Trademark Insiders.